Okay, Thomas Freed here. I just did a short video on how Section 61 is dead letter law because the original legislation it was enacted under expired in 1993. And I thought maybe I should go through and show why that's so important. Section 61, of course, is gross income. And why is that important? Well, let's take a look. We're using the Cornell Law Library here. We've got the United States Code, the table of contents. You can see here are the various titles, one, provisions, two, Congress, the president. We go through it. You got 54 titles in total. And here, Title 26, Internal Revenue Code. We go over there. And we have Subtitle A, Income Tax, Subtitle B, Estate and Gift, C, Employment Taxes, E, Alcohol, Tobacco, certain other taxes, firearm, subtitle F. So you have the subtitles of the income tax, and we're going to go to you have the subtitles of the tax code, and we're going to go look at subtitle A, income tax. All right, and here in subtitle A, income tax, you have chapter 1, normal taxes and surtaxes, chapter 2, self-employment, chapter 3, withholding, chapter 4, and so forth. So there are 6 chapters in subtitle A of Title 26, which is the income tax. We're going to go look at chapter 1, and we see there are subchapters. Subchapter A, determination of tax liability. We'll go there. And we see here we have part 1, subchapter A, determination of liability. Part 1, tax on individuals. Now, it's important to know that these titles mean absolutely nothing in the law. It says determination of liability, but it's only the statutes that actually do that, not the title of the entire group of them that was put together to organize it in the law. It's only the words in the statutes that have legal authority. Now, part 1 is the tax on individuals. Here we are, part 1, tax on individuals. And we have the Section 1, tax imposed. Now, it's important to remember that this is part 1. Part 1, that's important. Here we are in part 1 of subtitle A, and it's the tax imposed, Section 1. Okay, U.S. Code, Section 1, tax imposed. And what we have here is A, married individuals. There is hereby imposed on the taxable income of every married individual. It's not imposed on the married person. It's not imposed on the individual, but the taxable income. B, there is hereby imposed on the taxable income of every head of household. C, unmarried. There is hereby imposed on the taxable income. Every single one of these. Married individuals filing separate. Tax imposed on the taxable income. Every single one of these, the tax is imposed on taxable income. Okay, it's not the individual, it's not the person. So what is taxable income? Well, taxable income takes us to Section 63. Section 63, taxable income. Here it is. All right, taxable income is the taxable income means gross income minus the deductions allowed. Okay, so Section 63 is gross income minus deductions allowed. Let's look at the previous section. Adjusted gross income. Adjusted gross income is gross income minus the following deductions. Certain trade and business, certain trade. There are other deductions outside of Section 63. So gross income, adjusted, taxable income and adjusted gross income are gross income adjusted by certain deductions allowed under each statute. That takes us to Section 61, gross income. And this is the statute we're looking at because the tax is imposed on taxable income in Section 1. Taxable income is defined in Section 63 as gross income minus the deductions that are allowed. And Section 61 is gross income. And here we see that, except as otherwise provided in the subtitle, gross income means all income from whatever source derived, including but not limited to the following items: compensation for services, including fees, commissions, fringe benefits, similar items, income derived from business, gains derived from property, interest, rents, royalties, dividends, annuities, life insurance, pensions, discharge of indebtedness, distributive share of partnership in respect of decedent, interest from it. So you can see you have all these sources taxed. But one thing you should notice is that while compensation for services is taxed, salaries and wages are not taxed. Salaries and wages are not taxed here, where it's under gross income. Now, they are taxed in section 1441, withholding of tax on non-resident aliens. So where it's a non-resident alien, 1441B says withhold from salaries, wages, and compensations, 3 distinct and separate sources. So the removal of 2 of the sources in section 61 would appear to be intentional because there are 3 separate sources here. There is no intent for salaries and wages to be a form of compensation and therefore taxable. They're distinct and separate sources listed here in section 1441. So back in section 61, we have gross income, and now we're going to investigate gross income. Now notice that there isn't really any information here about the history of this code section. There's section B, which says items specifically included, see part 2. For items specifically excluded, see part 3. But there's no other information. So I went to the law library and decided to look this stuff up. And what I found at the law library is that you had section 61, and I looked this up in the United States Code Annotated, which is a more complete version of the statutes than just the regular United States Code. The United States Code Annotated version contains all of the source and resource information that you might want to review in reviewing the history of a particular statute. The laws have been recodified a number of times, and statutes changed numbers and changed places in the titles that are in the law when it was all reorganized to bring common statutes together so that it would be easier for attorneys to research the controlling authority for a case involving a particular law or a set of statutes regarding a certain matter. So it's important to be able to track and trace the origins of different code sections. And when we go to the annotated code version for section 61, what we find is that there's a footnote, number 1, right here's the footnote, that says the source for section 61 was section 22A in the 1939 code. So this is from the 1986 statutes, which came from the 54 statutes, and this footnote is preserved from the 1954 code that points you to 22A in the 1939 code. So here's another version of it in a different United States Code book. Here's section 60. Here's section 61, gross income defined, and again down here, history, ancillary laws, prior law, IRC 1939, section 22A. That's right here. Another version of the same section 61. Okay, so now let's look at what section 22A was. Section 22, gross income. General definition, gross income includes gains, profits, and income derived from salaries, wages, or compensation for personal service. Well, hold on. The footnote up here said 22A was adopted substantially unchanged. But right out of the gate, we find they took salaries and wages out of the code section. 22A contains salaries, wages, and compensation, all for 3 distinct forms, just like in 1441, when earned by a non-resident alien, all 3 distinct forms were taxable: salaries, wages, and compensation. The predecessor to section 61, section 22, included salaries and wages, but it was removed from section 61. Now, removing labor of the American people, salaries and wages, can only be earned by individuals, not corporations, and leaving compensation, which can be earned by a compensation, would seem to have some specific intent. What did section 22A do? Why did this tax salaries, wages, and compensation, and why did the government feel a need to remove salaries and wages from the code section when they recodified it in 1954 from 22A to section 61? Oh, well, let's investigate. Here, they still maintain this in the law. It's for parts from the 1939 code, the implementing parts of the 1939 law. It's still being used. And here we find section 22. 22 was implemented under the 1939 law under 26 Part 519. Well, now look, Section 40 was implemented under Part 1. Remember, Part 1 was important because that's the tax on individuals, the income tax. Section 1, that's Part 1. But Section 22 has no application within Part 1, only Part 519. Oh, well, this is getting interesting. Now, what is Part 519? Oh, well, look. All the 500 parts are tax treaties. And 519 is the Canadian tax treaty that was signed in 1918 and lasted for 75 years. So Section 22A was enacted as part of the Canadian tax treaty that taxed the salaries, wages, and compensation of Americans working in Canada. Nowhere else. Another foreign source of income. Non-resident aliens pay on salaries, wages, and compensation because they're foreign. And remember, the original act was the Underwood-Simmons Tariff Act, where a tariff is a tax on foreign activity authorized as an impost, which is the authority to tax foreign activity given to Congress by the Constitution, Article 1, Section 8, Clause 1. So Americans in Canada were taxed under Section 22A, and non-resident aliens in America were taxed under Section 1441. And in both instances, the application of the tax is foreign. The application of the tax is foreign. It applies to Americans in Canada and non-resident aliens in America. Those are the salaries, wages, and compensation that are taxed. And in 1954, when they recodified 22A to Section 61, I think it's fairly clear they intended to start trying to deceive the American people about sources of income. That's why Section 61 says they can tax from whatever source derived. All income from whatever source derived. They're intentionally trying to deceive you about the nature of the 16th Amendment to make you believe it created a new power to tax all of these things which previously were not taxable because they weren't subject to any impost, duty, or excise unless you were in Canada or were a foreign person in America. So here's 22A implemented under Part 519. Part 519 is the Canadian tax treaty. It expired in 1993. If you look this up now, Part 519 is reserved for future use in case there ever is another in the Canadian tax treaty or a treaty with Canada in the future. But as long as there isn't, it's reserved for use. The Canadian tax treaty expired. All of the legislation enacted with it, including Section 22A, now Section 61, expired. It hasn't been removed from the books, making it dead letter law. It's still there, but it no longer has any legal applicable effect that can be applied or enforced because the original legislation expired and Congress never reenacted it or with a greater applicability than it was originally given by the original legislation. Of course not. They would never want to call attention to the fact they've been taxing you as though you were an American working in Canada by deceiving you about the nature of gross income, because that's the only way they can get to interest, rents, royalties, dividends, alimony, annuities, life insurance, pensions, indebtedness, distributor shares. All of this is not taxable if it's not subject to some impost, duty, or excise taxation on commodities, licenses, corporations, imports, exports, foreign persons, or in foreign places. Without some federal subjectivity to impost, duty, or excise, gross income is irrelevant because you don't have any. It wasn't earned under the treaty, and it's not subject to tax through an impost, duty, or excise. It's only subject to taxation through your lack of understanding about the limited nature of the statutes and their origins. They've been taking advantage of the American people since World War II and the victory tax to make you think everything you do is taxable to the federal government. It's not. It never has been. It never was. The 16th Amendment doesn't create new authority, and Section 61 doesn't tax the gross income of the American people. It's dead letter law. The Canadian Tax Treaty expired in 1993. It was replaced by Bill Clinton with NAFTA, which means there is no longer taxation between the two countries. North American Free Trade Agreement. It's been dead letter law for 30 years. Now, in 2006, the IRS decided to publish in the C.F.R. applicability of Section 61 to Part 1. Oh, surprise, Congress didn't do that. The IRS did when they realized that this information was defeating them in court in the 1990s. So they changed the C.F.R. on their own. They made up a new application. Oh, it's applied under Part 1, but not because Congress said it. It's only because that's what they've been doing for 60 years, and they didn't want the fraud to be exposed. But here it is. Section 22 is where Section 61 came from. It was part of a Canadian tax treaty, and this is documented in every single law library in the country that has fiche records to document the past version of the statutes. Anybody can go there and pull this stuff up and prove it. And here it is written up in an article from the Save a Patriot Fellowship back in the early 1990s, describing exactly how Section 61 came out of Section 22A. It showed what Section 22A was, and then it showed that Section 22 is only applicable under Part 519. Again, notice that Part 40 has Part 1, but not Part 22, and Section 61 isn't shown. Section 62 is shown as Parts 509, 513, 514, 520, and 521, all tax treaties with countries in Europe. So adjusted gross income only applies to tax treaties with countries in Europe. All these 500 parts, all the 500 parts are tax treaties. 519 was Canada, it expired. This is like Ireland, France, they're European countries. We can go back and look at them if you want. We'll have to trace them. What are the numbers? 9, 13, 14, 20, and 21. 9, 13, 14. Okay, 9 is Switzerland, 13 is Ireland, 14 is France, 20 is Sweden, and 21 is Denmark. They're all European countries that adjusted. That's why they needed adjusted gross income to modify gross income for work in the overseas country. The statute could have told you that, but then they would have revealed the fraud being perpetrated on the American people. And here it is, Section 22, Part 519, the Canadian Tax Treaty, and now it's reserved for future use. The whole thing is a fraud. Section 61 has never defined the taxable income of the American people. It's only defined the taxable income, being gross income, of those persons working in Canada under the tax treaty between the years of 1918 and 1993. It has no other published application or implementation in law. None. None that was enacted by Congress. As I say, in 2005 or 2006, they added an entry to try and create the appearance, for those not adequately informed on how to research the law properly, create the appearance of application to what they're doing now, which of course is the enforcement of a direct tax without limitation on everything you do, making you a slave. All they have to do is raise the rate to 100% and it'll be realized. That's not what the 16th Amendment did. That's not what the original statutes did. It's not what the original income tax legislation did. It's not what the Canadian Tax Treaty did. It's not what the recodification of the statute to Section 61 in 1954 did. Every single bit of that is fraud. And if you want to know more, you need to go over to the Thomas Fried channel on YouTube and watch the video, the playlist on the income tax fraud exposed. It's a 4 or 5 hour playlist with a couple of other videos added to it, as I'll be adding this to that as well. So that's the bottom line on the IRS, the federal income tax, and gross income. It's not from whatever source derived. They're directly going to the 16th Amendment to make you think that a new power to tax your labor was created and was enacted, and neither one of those false beliefs is true. They're both false beliefs. And this is all easily verifiable. And if you want a copy of these documents, they're available at irszoom.com. It's the exhibit document package for just $20, which shows this part of the law, Section 61, as well as everything else that you need to know and ought to know, to go along with the audio lecture that I provide. You listen to the audio lecture once, you can follow along with your own exhibits, and then you'll be able to teach other people the truth about the law, including attorneys and judges who are not able to refute any of this information or statutes other than to assert that they're enforcing judicial legislation, their own opinions, instead of the statutes. And my response to that is, that's the problem. You're not authorized to enforce your opinions in place of the statutes in the history of the law. You're authorized to enforce the written law as written. But if they did that, they couldn't enforce the income tax on the American people and their right to work or the fruits of labor derived from the simple exercise of the right to work. Because rights aren't taxable, the Constitution doesn't authorize it, regardless of the 16th Amendment, and the statutes never implemented a tax on the American people. Only taxable income, which was gross income under the Canadian Tax Treaty, and on non-resident aliens who are privileged in being allowed here to work and are subject to the tariff and its collection. The whole thing being about collection of the tax at the source, not a direct tax on the labor of all persons. It's a fraud. If you want to get informed, go over to taxfreedom.com or go over to irszoom.com and pick yourself up a copy of The Simple Truth About Income Tax for just $4. It has everything in it about the original income tax and explains the problem with trying to take subject matter jurisdiction under the 16th Amendment that has no enabling enforcement clause to authorize Congress to write any new law under the amendment. And in order to take subject matter jurisdiction, the court has to show that Congress was authorized to write the law allegedly being brought to bear by the government upon the defendant with its either civil or criminal complaint for the enforcement of the tax. So there you go. If you like the video, like the video. If you want to get informed, subscribe. And head on over to the channel. Check out all of the shorts and the other videos I've put up. They're all good. They're all quick. They're all short. They take you right to the bottom line on the matter of what's going on. Federal income tax. So it's a fraud, and you should get educated and get informed so you can learn how to set yourself free.